Mr. Shaw, will you just bear with me for a moment before you get on to the next part of your submissions? It's just on a practical point, and it's something that arises from a question that my Lady Justice Asplin asked you that I've been pondering about over the short adjournment. So I wonder if you could just give me the practical, as it were, context, so I know where we're going forward. It's quite obvious from the judgment that experts were called before Mr. Holland, and he made his decision there. There was also Mr. Simmons, who was called on the point of the £200,000 injection of cash. Yes. Did you, on behalf of Mr. Davies, seek to call any further evidence as to matters that may expand those points in paragraph 272? So going beyond, as it were, the findings that Mr. Johnson had been able to make. By that time, you'd got the liability judgment, which said that with all of this morass of evidence, and I'm paraphrasing, obviously, you understand, you know, it's very, very difficult to come to conclusions. There are omissions, there are lacunas everywhere, but these are the 7 things I can come to, and we know what your argument is on that it is not exhaustive. So did you, having seen that judgment, seek to call before Mr. Holland, bearing in mind your interpretation of the order that you've taken us to, did you seek to put before him any further evidence to clarify that mass of evidence that Mr. Johnson hadn't been able to get to the bottom of?
No, I don't think so. Before Mr. Holland, there was factual evidence and expert evidence.
Yeah.
My client, Mr. Davies, made a witness statement, was cross-examined.
Yeah.
Although, I mean, bluntly, there wasn't much he could say because at the quantum, I mean, it wasn't really about his conduct anymore. No. Mr. Monks made a witness statement, and I cross-examined him. He put forward various reasons why he said that the business conducted by GBRK could not have been conducted by GBR. So, for example, he said that there were regulatory matters, which meant that GBR would not have been able to trade. And Mr. Holland rejected those arguments, and yes. I've taken you to paragraph 155. But if you are, I mean, I didn't.
But it's just, for example, because we're going on to C at the moment, aren't we? Ground C eventually. Yeah. Well, eventually, pretty soon, I think.
I hope so.
But in that case, you ask us to come to a conclusion that, in fact, there was evidence there about the removal of 21,000 odd.
Yes. From
the bank account, which yes. came from the evidence of your, forgive me.
Correct, Mr. Hayward Crouch.
It was your...
No, sorry, it was Mr. Monk's expert.
Mr. Monk's expert. Yeah, and we'll come to that in a moment. It's just, I'm just wondering if there was any other evidence around these matters that could have firmed up 272.
I mean, I didn't ask I didn't ask Mr. Holland to make further findings of breach of duty, albeit it was part of my pleaded case. I showed you that this morning. But yeah. I mean, my position was, and it remains today, I didn't need to, because as far as I was concerned, what the court was engaged in at the quantum stage was the taking of an account, which means working out what the trust property is and where it's gone, and at the end of the day, awarding a remedy. So I don't know whether that answers your ladyship's question.
Yes, it does. Yeah. Yeah, thank you. It does. Thank you very much.
I was going to take the court to the authorities my learned friend relies on ground B, so the cases which say you need pre-existing trust property. In the interest of time, I won't take you to both because you'll know what I'm going to say about them. One is a decision of the Scottish Outer House, Commonwealth Oil and Gas against Baxter. The other is a decision of the Australian High Court, Farrer Construction. I'll take you to Commonwealth Oil and Baxter because Mr. Holland relied on that in particular. I'll give you the references to the Farrer Construction case, but I mean the submission is essentially that these are obviously they're persuasive, yes, but
Mr. Baxter, sorry.
Sorry, the case is called Commonwealth Oil and Gas against Baxter. He was the.
You just said Mr. Baxter relied upon it particularly. Did you mean Mr. Cook?
Oh, sorry.
I think you meant Mr. Cook.
Sorry, everyone's getting confused. Yes, Mr. Cook relies on but the point I make is that these may reflect the law in other jurisdictions, but they don't reflect the law here, which is as stated in Buller and Buller. So my favourite case. So Commonwealth Oil and Gas is at its authorities bundle 1 tab 32 and starts at 748. The diversion in this case involved something described as a memorandum with a state oil company. It was diverted to the second defender, Eurasia Energy Limited. You see, so the second paragraph in the head note, the pursuer raised an action against the defenders seeking account. And then the second sentence, the person also the second defender knew, in light of the first defender's position holding in the second defender, the first defender had secured the memorandum on its behalf in breach of his fiduciary duties. So it's a new property case, if you like. I could take you first of all to actually probably the only thing I need to show you is the decision of Lord Nimmo Smith, who gave the main judgment, and you can pick it up at page 776, paragraphs 94 and 95. Clear from the authorities quoted above that knowing receipt depends in the first place on the prior existence of an asset which is subject to a trust in favour of the beneficiary. It's the disposal of that asset in breach of duty and the receipt of the asset by the recipient in knowledge of that breach, which together give rise to a constructive trust. So, I mean, that is that's the key conclusion, and Mr. Holland relied on that. What is interesting about this is that the court was aware of Buller and Buller, and if you go back to paragraph 82.
Sorry, page?
Paragraph 82, page 772.
Thank you. Thank you.
You see in paragraph 82 there's reference to Lord Justice Jonathan Parker's judgment in Buller, but it's not relied on for this purpose. The point the point that's being made here, the question was whether whether a fiduciary owes an independent duty to disclose his or her own wrongdoing, above and beyond the duty to promote the success of the company. And so you can see that the court had been referred to Buller and Buller, but it doesn't appear from the report that the argument was put, that the argument I put today was advanced to the court, which is that Buller and Buller stands as authority for the proposition that you don't need existing trust property.
But it does look from paragraph 94 as though Lord Nimmo Smith was referring to, yes, the key places on knowing receipt, and he refers to illegal and dollar land, which is normally the starting point.
My lord, I accept that. The point I'm making is it's not a certainly I see that paragraph 94 stars. It appears to me clear from the authorities.
Yes.
But it doesn't. There's certainly no discussion of Buller and Buller in this context.
No, fair enough. Yeah.
And so.
Yes. On the other hand, I mean, the sentence on which Mr. Cook relies is obviously against you and does appear, at least in the view of this particular court, which after all is a court equivalent to the Court of Appeal, they appear to have regarded it as plain law that was correct.
My lord, yes, I have to accept that. But I mean, I mean,
it's not binding, but it is obviously persuasive.
It is persuasive, but I say that there is as a statement of English law, I say it's incorrect. It's inconsistent with Buller, and without going through the submissions I made this morning about Cook and Deeks, I say it's also inconsistent with Cook and Deeks.
Yeah. Anyway, thank you. We have your submissions on that.
Perhaps I could just give you the reference to Farrer Construction. It's Authorities Bundle 1, Tab 30. The relevant paragraphs are 118 to 121. The Australian High Court reached the same conclusion as the Scottish Outer House in Commonwealth Oil, that pre-existing trust property is a necessary ingredient of knowing receipt. But you will see that, well, first of all, it's an Australian case, it's not an English case, but the court proceeded, but the discussion of this point was based on a concession that confidential information was not capable of founding a knowing receipt claim. So it started from a concession made that an opportunity is not capable of founding a knowing receipt claim. So the point is, again, I say, well, it's of course a very respectable court, but it's not an accurate statement of English law.
It might be unfortunate if the Australians took a different view from us, and of course it's possible, but one of the points made in FHR as a reason for deciding it as the way the Supreme Court did was to achieve, or help to achieve, a common approach in different Commonwealth jurisdictions.
But Lord, yeah, I see that, although, I mean, of course, there are differences, because in Australia, for example, they would see, they talk about knowing participation. They don't see accessory liability in quite the same way.
Yeah. Fair enough. Yeah. Thank you.
Unless the court has any further questions for me on ground B, those are my submissions on.
No, thank you very much.
I'll move on to ground C. I will deal with this really very quickly. It is obviously of not vast monetary value, although it may have consequences. But this point really only becomes, this point is only relevant really if you are against me on ground B. If you come to the if you are with me on ground B, and so that you reach the conclusion that pre-existing trust property is not a necessary ingredient of a knowing receipt claim, then we don't need to worry too much about whether property originated in GBR and was transferred to GBRK, or whether it's new property obtained by GBRK which should have been obtained for GBR. But if you're against me on ground B, then there was evidence before the court in the report of Mr. Monk's own expert, Mr. Hayward Crouch, that in the second period, so after the 22nd of May, which is the time bar for the claim against GBRK, pre-existing trust property was taken from GBR and used for the benefit of GBRK's business. There were two.
Was it as definite as that? Because that which you quote is more nebulous.
Well, I was going to show. I was going to show you the report. I don't want to misrepresent what Mr. Hayward Crouch said. It should be. There are two supplemental pages. It's Bundle 3, Tab 11, pages 159A and B.
Bundle 3, did you say, Mr.
Yes,
Brown?
Bundle 3.
Tab 11.
Yes.
And the reference within?
It should be pages 159A and 159B. And there's a table at paragraph 3.4 of Mr. Hayward Crouch's report. And if you look at, if you look towards the bottom of the table, the second column,
LTSB receipts,
21,000.
Yeah.
And then if you read on, it's paragraph 3.6 is the one I rely on in particular.
So it appears likely that. But if you look at 3.5, it says most entries have insufficient detail to allow me to determine whether they address a GBR liability or GBRK related expenditure, and hence whether there was a benefit received. Of Lloyd's TSB factoring receipts, it appears likely that the 21,000 received from May to August was withdrawn and or utilised. So, is that the best it got to?
It was. I mean, what Mr. Hayward Crouch said at 3.5 is that up to March 2011, it wasn't clear whether withdrawals from GBR's bank account had been spent meeting GBR's liabilities or GBRK related expenditure. But from May, which is that's important for the purposes of the claim against GBRK, because the 22nd of May 2011 is the time bar. What was received? He warms up and is asked what was received between May and August 2011 is likely to have been used for the benefit of GBRK. And I would say, well, if you look what was going on the ground, it's difficult to come to the conclusion that it was used for any other purpose, because we know that GBRK was already trading at this point. That was Mr. Monk's own evidence. Mr. Monk's gave evidence that GBRK started trading in March or April. Mr. Holland rejected that and said that his conclusion was that GBRK had started trading in February 2011. But
at this stage, GBR was still in existence, wasn't it?
It was in existence, so it wasn't doing
up until the October.
Yes, it was in existence, but its bank accounts had been emptied. It wasn't doing anything. So obviously it should have been, but it wasn't.
Well, weren't they clearing the site at this stage?
Yes, they were, and
which was
that was largely covered in the liability judgment. But the clearance of the site was for the benefit of GBRK, because GBRK carried on trading from the site.
Well, I think, wasn't it a requirement of the local authority that the site be put into appropriate order, because there were breaches of the regulation which implicitly could have led to prosecution and penalty.
Yes, that's correct.
So GBR would be liable.
My lady, I'm not sure that's right, because the
licence was held by another, wasn't it?
The licence was originally held by the freeholder.
Yeah.
GAL.
And for a while it was possible.
And then Mr. Monks procured the grant of a waste management licence to GBRK, and that was one of the matters that Mr. Johnson dealt with in paragraph 272. The licence should have been taken by GBR.
But it was taken once the site had been put in order?
No, I think it was.
We can check that.
I think that it's in the liability. No, I think I'm just trying to remember the timing. I think the site, the clearance of the site went beyond the
cut-off point.
Yes.
Yeah. Okay.
so I rely on paragraph 3.6 as it's not my own evidence. It's Mr. Monk's, the evidence of Mr. Monk's expert, as evidence that money was taken from GBR and applied for GBRK's benefit. Essentially, 2 points are taken against me here in my learned friend's skeleton. The first one is he says, well, Mr. Monk's denied that the money was used for GBRK's benefit, to which I say, well, of course he says that. What else would he say? So that can be discounted straight away. The second point perhaps deserves a fuller response. My learned friend says that there was no receipt of trust property. So, if you like, it's a different issue that's raised here. It's not a point about pre-existing trust property, but what he said is there was no receipt by GBRK of that trust property. And my learned friend relies on the Saudi National Bank case that Lord Sir Launcelot mentioned this morning. That's at Authorities, Bundle 3, tab 58. Page 2130.
Oh, that's the case I was calling buyers. Yes, sorry, I was confused. It's the same one.
What I anticipate my learned friend is going to focus on is paragraph 21, which my learned friends have marked, 21 and 22. It was suggested by counsel for the claimants that it sufficed for liability that the defendant benefited from trust property regardless of whether he actually received it. And an example is given, well, what about if a trustee wrongly spends money on trust money on a holiday for the defendant? And the Court of Appeal said that's not, success in a knowing receipt claim depends on establishing beneficial receipt of assets.
Yeah.
But what I say here is that there is a material difference. It is one thing if a trustee misuses trust money and pays for a holiday and takes his partner on holiday, well, his partner hasn't received, isn't a knowing recipient. But the position is different in circumstances where where GBRK has incurred liabilities. And what I say is that if GBR has paid third parties, so has discharged liabilities of GBRK, that is receipt by GBRK. It is the same as handing over cash to GBRK, which GBRK then uses to pay a creditor.
But do we know any of that?
Well, I can show you what we do have. It's file 3. These are the bank statements that Mr. Hayward Crouch has relied on in producing that table at paragraph 3.4. So tab 19, they start at 262. See it. So at 262, there's a reference to 31st of May 2011. Our monks. Sorry to put this in context. These are GBR's bank statements, and so what you're seeing here is withdrawals from GBR. So paid 6,500 paid out to Richard Monk's Greenbox Recycling. Over the page, 263. 28th at 8th of June rather. 4,000 is withdrawn, and then 20th of June, our monks repayment of fuel, 5,500, and then over the page, 12th of July 2011, repayment of fuel, £2,000.
But what does repayment of fuel mean?
Well,
It means
I mean, given
repayment might mean, and we're just speculating, but might mean Mr. Monk's paid for it and then recouped that money from GBR in respect of the fuel that he'd purchased. So it doesn't mean that it necessarily went to GBRK at all.
well,
We'd need lots of more surrounding facts to know what that really means.
Well, I mean, I agree. The evidence is limited. I mean, I endorse Mr. Holland's comment that when the facts are messy and you've got a defaulting trustee, then I mean the uncertainty is to be resolved against the trustee. But
Absolutely.
But I mean, no, I don't know. I mean, on what all that I can say is, I mean, what this appears to be is Mr. Monks has paid for fuel. If you look at the sums involved, this isn't just filling up the car. Mr. Monks has paid for fuel. It is to be inferred that is for the purposes of the business, and he has helped himself to GBR's money to recoup the amount, the sums that he's paid out. I accept that on the face of it, I can't say that the money passed into GBRK's bank account, but I say it didn't need to, because if GBR discharged a liability of GBRK, and the payment was accepted, in this case by Mr. Monks, then GBR must have been paying as GBRK's agent, because otherwise the liability wouldn't have been discharged.
Was that subject of any cross-examination when Mr. Hayward Crouch was giving evidence? Paragraph 3.6, sorry.
Yes, it was, and you don't have the. I mean, we can certainly supply you with the relevant part of the transcript. But what Mr. Hayward Crouch, I think this is fair to him. He said his conclusion was it was likely to have been spent on GBRK's business, but he just couldn't go further than that because he didn't know. He didn't have the documents. Okay,
so he was, being very professional about his expert code, as it were.
Yes. That's all I intended to say on ground C, unless there's anything further I can help you with on that.
No, thank you.
Ground D concerns my claim against GBRK to a declaration that the site is held on constructive trust for Mr. Davies. Just to put this in context, once again, this point is important anyway, but it becomes particularly important if you are against me on ground A. So if you conclude that my client's right to relief is limited to paragraph 272 of the liability judgment, then the grant of the second lease on the 23rd of June 2011 was the only one of those 7 matters which occurred within the limitation period.
Sorry, that was the grant of the second lease.
Yes, Mr. Monks took the second lease on the 23rd of June 2011, so that's the only one of the 7 matters listed in paragraph 272 which occurred after the 22nd of May. I've dealt with this in my skeleton argument. Just if perhaps we could go to that just so I can set out the chronology. I've dealt with is tab 5, page 37, bundle 1. If I could ask you, I'm sure you're familiar with this, but if I could just ask you to skim paragraphs 68 through to 74, it just explains the relevant chronology here. So the position was that at some point after GBRK had been incorporated, we don't know precisely when, but before the 22nd of May in any event, Mr. Monks caused GBRK to take a lease of the site. I called that the first lease. That was the date of, that was the terms of that provided for it to begin on the 7th of December 2010. On the 23rd of June 2011, Mr. Monks took a lease for himself, the second lease, on terms which preserved the first one. So, as Mr. Holland found, the second lease was interposed between the freehold owner and the existing lease. So, the second lease preserved the first lease as a sublease. And Mr. Holland correctly concluded, and there's no appeal against this, that Mr. Monks took the second lease on trust for GBR. In 2015, Mr. Monks assigned that second lease to another of his companies, GRL. Again, Mr. Holland held, and we say correctly, that GRL acquired the second lease as trustee for GBR.
Sorry, assigned to...
So it's to a company called Greenbox Resources Limited. I've dealt with this paragraph 73.
Yeah.
And so again, there's no appeal against Mr. Holland's finding on this point. GRL took the second lease as trustee for GBR. There was then a renewal. We can probably put that to one side. But then on the 1st of July 2016, GBRK purchased the freehold of the site, and by way of a connected transaction, GRL surrendered its lease, surrendered the second lease, which left GBRK as the holder of the freehold. I put my argument into, I put my claim to the freehold in two ways before Mr. Holland, and he rejected both of them. I obviously say he was wrong to do that. The first one focused, the first way of putting the case focuses on what happened on the 23rd of June 2011. And what I say is that GBRK received something on that day. So it was a knowing recipient on that date, and it should be treated as having received or re-received its rights under the first lease. So I explained that. But if I'm right about that, then the consequence is that you get to 2016, GBRK was not entitled to buy the freehold. It's a straightforward application of Keach and Samford. The second way I put my case is to say, well, if I'm wrong about that, if my first argument is wrong, even if GBRK didn't get anything on the 23rd of June 2011, the second way I put my case focuses on Mr. Monk's position as trustee of the second lease. Mr. Monks was trustee of the second lease. Then his company GRL took an assignment. As I've just explained, Mr. Holland held that GRL took the second lease subject to GBR's equitable interest. And so what I say is that you get to 2016, you have a situation where GRL holds a lease on trust for GBR. Certainly GRL was disabled from buying the freehold. Again, that's just Keach and Sanford. Mr. Monks doesn't escape the application of Keach and Sanford by the happenstance of another one of his companies, GBRK, buying the freehold. If I can deal with each of those different cases in turn. I say that that GBRK received property capable of founding a knowing receipt claim on the 23rd of June. And that is because the transactions which took place on that date secured GBRK's occupation of the site. And that was Mr. Monk's own evidence. I will just refer you to the quantum judgment, tab 17, bundle 1, page 345. Mr. Holland has set out Mr. Monk's own evidence, set out the words used by Mr. Monks in cross-examination. Mr. Monks said, yes, the second lease secured the site to trade from, definitely. That's what it did. It secured the site, yes.
So what is it that you say that GBRK received?
Well, it should be treated as having received or re-received its rights under the first lease. And I say that because that's not sort of rewriting history, and that's not straining anything, because Mr. Monks controlled GBRK. So it would have been perfectly open to him to have caused GBRK to surrender the first lease. If the landlord had been willing, he could have caused GBRK to take the second lease. Mr. Monks controlled GBRK. The deal he did with Benchmark, the buyer of the freehold, was he took the lease himself, but on terms that preserved the existing lease. So what Mr. Monks has done is interpose himself between GBRK and the freeholder. I mean, as Mr. Holland has found, the existing lease, the first lease, took effect as a sublease. So before the 23rd of June 2011 transactions took place, you had the former freehold owner, GAL, had granted a lease to GBRK. On the 23rd of June, that changed, and what you had was Benchmark bought the freehold, Mr. Monks took the head lease, and then the existing lease was continued as a sublease.
I'm sorry, this is almost certainly me being obtuse. I still haven't got the relationship between the lease and the sublease right at this stage. And I thought the second lease was for a term 1 day shorter than lease 1. I got that the wrong way around. If so, I don't see how lease 1 could have ended up as a sublease.
Well,
Maybe it's missing something very obvious.
So that Mr. Holland found that, it's paragraph 254, so it's page 342.
Yes.
And these weren't my arguments. These are the relevant facts as found by the judge. 254F.
Well, yes, I know, but I've put a question mark in the margin, so I wasn't quite sure I'd understood that. It says, thus the second lease was expressly made subject to the first lease, and thus, on that date, GBRK became a subtenant of Mr. Monks. I mean, does that reflect the general law of property on what happens if you grant a concurrent lease? Or does this turn on the fact that there's been no permission granted for lease 1 and it was just therefore precarious? But that
Yes, it was.
But that doesn't turn you into a subtenant. Then you have the second lease was for 1 day. I thought. Sorry, I have made a note. It was the second lease that was for a shorter period than the first one. In which case, you'd expect that second one to be, if anything, end up as a sub.
I see my lord's point. I think, your lordship is right that I think Mr. Holland accepted it was at least possible that the first lease was vulnerable.
Yes, that's a different point. I mean, it was liable to forfeiture.
Yes,
presumably for lack of the mortgagee's consent.
Yes.
Yeah.
Yes.
But that doesn't answer the property law question, which is what is the relationship between lease 1 and lease 2 as a matter of land law?
My lord, I see that.
Well, I don't need an instant answer, but perhaps at some point somebody could give that a little thought.
I mean, I anticipated somebody might ask me this. It seemed to me that there could, just a sort of matter of basic principle, there can't be. I mean, of course, you can have 2 leases over 2 separate parts of a freehold estate, but you can't have 2 leases sitting at the same level. I mean, there must be.
Well, one has to take priority over the other, and I would have thought, on a matter of principle, the first lease would take priority, albeit it's subject to forfeiture, and then you have a concurrent lease, which would come into effect
perhaps, my lord, you can leave that with me, and I'll.
Okay,
yeah.
thank you.
Yes. I mean, the point I make about this really is that Mr. Monks was in control of the transaction.
Yes.
And if GBRK had taken the second lease, there would be no difficulty in saying that from the moment of entry into the lease, that estate was impressed with a trust in favour of GBR. And so, say this isn't sort of reconstructing facts in a very real way. The transaction on the 23rd of June secured, it removed the vulnerability which existed in relation to the first lease. GBRK should be treated as having received its rights, or if you like, its rights for the remainder of the term on that date.
So this is dealt with, as you say, in 254, and the first lease was obviously vulnerable because Barclays had not consented.
Correct.
So Mr. Monk himself takes the second lease, as Mr. Holland says, you call it, for the same term, because it's for it terminates on the 29th of November 2017, as would the first lease. Yeah?
Yes. Yes.
So and therefore, I'm terribly sorry. GBRK became a subtenant of Mr. Monk's. That's what Mr. Holland found in F. Second lease made expressly subject to the first lease. Thus, on that date, GBRK became a subtenant of Mr. Monk's. It's accepted that Benchmark was not connected in any way with the defendants, and the purchase and subsequent grant of the second lease were arm's length transactions. And that's obtained from the liability judgment 232 and 237. Or is it 232 and 237 of the quantum judgment? In any event, that's a finding.
Well, my lady, yes, and
I think it's of the liability actually, because 232 of this judgment is talking about something else. But it is the same term, isn't it, Mr. Shaw? Because
yes, I'm sorry, I must have misremembered that. I thought the second one was for less 1 day, but the original one was also for 7 days.
So
7
it
years,
was
less a day, was it?
Yeah, at D.
In which case we have 2 concurrent leases for the same term.
Yes, absolutely.
And I know there's some law about this. I guess I'm afraid I've just forgotten what the answer is. As to what
produces. My learned friend and I will have a think. But
okay,
I as a matter of first principle, I don't I'm not a property lawyer, but I don't really see how you can have concurrent leases sort of sitting at the same level behind the freeholder.
Well, the answer is maybe yes. I mean, obviously the second one can only take effect if and when the first one. Maybe I think it's perhaps a reversion release. Maybe that's the right way of looking at it, rather than a subtenancy. But I'm trying to stop thinking aloud, or just get us all into more confusion on this.
Well, Mr. Holland doesn't seem to think that the second lease, because he keeps saying that you refer to it as the second lease, Mr. Shaw. So perhaps he took my lord's point that it was a reversion release.
Well, my lady, he didn't say that. I think this.
But it says Mr. Shaw calls this the second lease.
I don't think he was being. I don't think that was intended to be disparaging. I think. It
Oh
was
no.
I think it was just we just. There were three separate leases to consider, and I think
Yes.
I mean there might be a better term for it, but I don't think Mr. Holland was treated it as a reversion release. So if you see what he said about what I call the third lease,
Yeah.
that he did describe as a reversion release at 254J on page 344.
Yeah. It was to commence immediately on the expiry of the term of the second lease, which would also be the end of the first lease.
I think it's just that relationship between the first and the second lease that we don't understand, and it's the last line of F about the subtenancy, which is baffling.
Yeah. And then, as I said, Mr. Holland rejected my case, and that's you get that from paragraph 260. And really, Mr. Holland here is making 2 points. First of all, he says he didn't accept that GBRK obtained any benefit as tenant under the first lease. He recognised the possibility the first lease was precarious because it was granted without the mortgagee's consent. So, it became more secure. The fact it became more secure had nothing to do with the second lease. And then the final sentence, you see, he said, I don't suppose. In any event, I do not think the supposed benefit or advantage of gaining greater security can constitute an asset or property receipt of which can found a claim in knowing receipt. Well, dealing with those points in turn, I say that it's too compartmentalised a way of looking at the transaction on the 23rd of June to say that the security obtained by GBRK was only obtained through through the purchase by Benchmark of the freehold. There was a composite set of transactions. Benchmark bought the freehold, and on the same day, Mr. Monks took the second lease. I mean, commercially, there was one deal. And as to the second point, well, we've had a lengthy discussion about pre-existing trust property, but what I say here is that. You've heard what I've said. It's not straining the facts to see that GBRK got the first lease, or should be regarded as having been granted the first lease or the remainder of the term of the first lease on the 23rd of June, because the function of the transaction was to secure GBRK's position.
But it looks as though that wasn't recognised by Mr. Monk until the 23rd of June. I mean, up until that point that Benchmark did become the freeholder, presumably there was nothing Mr. Monk could do, save to seek the consent of Barclays.
Yes. But the terms of the point was that the second lease was granted was granted expressly subject to the existing lease, the first lease. So that it was that which secured, in my submission, GBRK's position as occupier of the site?
Well, only because Mr. Monk would not put GBRK out onto the street, as it were. He was there, according to this, he was effectively their landlord, GBRK's landlord.
Yes, and I mean, subject to my Lord Sir Launcelot's point, I do on Mr. Holland's analysis as it stands, Mr. Monk's became what was tenant under the head lease, and he granted a sub-tenancy to GBRK. So that's why I say Mr. Monk's kind of interposed himself.
Perhaps maybe the answer is lease 2 was 1 day longer than lease 1. I think that may be the answer, because lease 1 was for, I now lost what day it expired on.
It commenced on the 1st of December 2010 for a term of 7 years less 1 day. So that would be the 29th of November 2017.
Yes, whereas then we then turn to lease 2, which was for a term of
exactly the same time.
no, it's not exactly. Sorry, I think it was
According to
a term of 7 years. I'm sorry, I've lost the reference to it.
So in F, we see on 23rd June, Benchmark granted a lease to
That's
Mr.
right.
Monk for a term commencing 1st December, terminating 29th of November 2017.
Yeah. Yes.
So that would be the same term.
But I think, can I just be clear about what you're saying about paragraph 260? Halfway down, the judge says the first lease became more secure, but that had nothing to do with the second lease. It was due to the freehold of the site being purchased by Benchmark, which company was, together with its mortgagee, so we've got a new mortgagee, content to allow the first lease to continue, albeit as a subtenancy. So are you saying that Mr. Holland was wrong, that in fact the new freeholder and its mortgagee could have chosen in fact to say that it wasn't content for the first lease to continue? Are you saying that that is wrong because Mr. Monk was interposed and he was providing that umbrella security shadow, whatever you like to call it?
Well, I put it in both ways. I mean, my primary point is to say that it's artificial in my submission to sort of divide up the sale of the freehold and the grant of the lease, because commercially it was all done as one. Benchmark bought with a view to leasing the property to Mr. Monk's, and so my primary point is about you have to look at the thing in the round. But yes, I adopt my lady's point. I mean, if that's wrong, then there's this point about interposing Mr. Monk's between the freeholder and GBRK.
But this was an arm's length transaction.
As regards Benchmark, yes,
Yes.
it was. Yes.
Yeah.
So, if the court is with me, I mean, if you conclude that GBRK acquired the first lease or the remaining term, it held that on constructive trust from the 23rd of June, then we say that a straightforward application of Keach and Sanford meant that as trustee it was disabled from buying the freehold. If you're against me, I then fall back on the second point I made, which focuses not on GBRK's position on the 23rd of June, but on Mr. Monk's status as trustee of the second lease. There are unappealed findings. Mr. Monk's held the second lease as trustee. Just to pause there, this is actually very important, just if we take a step back from all of this. GBRK was only able to trade as a result of its occupation of the site. the lease, the second lease, was held on trust for GBR. So what Mr. Monks has been able to do is use GBR's property, cost-free. Again, there's no appeal against this. Mr. Monks assigned the second lease to his company GRL in 2015, and then on the 1st of July 2016, another composite transaction took place. GRL surrendered the second lease, and GBRK bought the freehold. So GBRK is left with the freehold. It's no longer a reversion. It's an absolute interest. I've referred to two authorities, Prothero and Prothero's decision of this court. That stands to the proposition that the trustee of a lease cannot purchase the freehold, applying Keach and Sanford. I won't take you to that. I will take you to Thompson's trustee. The reason is that Thompson's trustee refers to the relevant bit in Prothero. That's authorities 1, tab 8, 102. What happened? This this concerned the purchase by a company of a freehold. The background was that T&H were partners. They held a lease of the farm. The partnership was dissolved, but final accounts weren't drawn up. H then formed a company. He was a 50% shareholder along with his wife. The company then purchased the freehold of the farm. The company then resold the farm at a large profit. And then 1971, in the meantime, the partner T was bankrupt. The trustee in bankruptcy came along, seeking claiming that the freehold reversion and net proceeds of sale were held on trust. If you go to page 109, if I could just ask you to read from 612B through to, sorry, page 109, law report, page 612, but from B to F. So you see the short passage from Prothero and Prothero. And then at 110 G to H, you see that the Vice-Chancellor concluded that the company in which H had a 50% interest was in no better position than H himself. And so the company held the property on, held the freehold on trust. So applying Prothero and Thompson's trustee to the facts of this case, we know that GRL was the held the second lease on trust for GBR. GRL was disabled from purchasing.
The second lease was held on trust by Mr. Monk.
And then he assigned it to Greenbox Resources Limited.
Thank you.
So we know if Greenbox Resources Limited had purchased the freehold on the 1st of July 2016, it would have taken the freehold on trust for GBR. Relying on Thompson's trustee, what I say is Mr. Monks doesn't escape that rule by causing another company, another one of his companies, GBRK, to acquire the freehold. The Vice Chancellor and Thompson's trustee wasn't troubled about the fact that the purchase of the freehold had been by a company in which the fiduciary had a 50% interest. The fiduciary did not escape Keach and Sanford by buying through a company. We say the same here.
But it was Mr. Holland saying that the relevant benefit was by virtue of Benchmark's purchase rather than second lease. That's why he held against you.
Well, that was on the first. That was on the first way I put the case.
Yeah.
I mean, if you like, the first way is sort of shorter. If you are with me, and if I'm right in saying that GBRK should be treated as having received something capable of founding a knowing receipt claim on the 23rd of June, then GBRK, then that property, the thing it got, was impressed with the trust from the 23rd of June, and it meant that GBRK could not buy the freehold. But if I'm wrong about that, then I have to, then the focus turns to Mr. Monks and the assignee of the lease. What I think my learned friends say is that they say this doesn't work because by the time you get to 2016, GBR had been struck off and dissolved for years, and so Mr. Monks didn't owe any more duties to GBR. We've been through that. That was the conclusion reached by Mr. Johnson. But my answer to that is it doesn't change the fact that it was trust property. We know it was trust property. Mr. Holland found it was trust property. The consequence of restoring GBR to the Register of Companies is that everything which GBR is deemed always to have been in existence. So the strict legal position would be this, that during the time when GBR was struck off, the lease was held on trust by Mr. Monks GRL for the Crown as bona vacantia, but upon the restoration of GBR is deemed always to have been in existence. It's always been trust property. So what I'm really saying is that my claim to the freehold, it's not based on some fresh breach of duty by Mr. Monks as director. It's simply the fact that you have trust property, so it's property in which the legal title is held by one person and the beneficial interest is held by somebody else. That person is not entitled to buy the freehold. It's got nothing to do with Mr. Monk's duties as a director, and it's nothing to do with this isn't founded on an allegation that GBRK was a knowing recipient on the 1st of July. This is just an application of straightforward Keach and Sanford principles. Before we move on, I should just deal with one final point the judge made at paragraph 269. Mr. Holland put to me, he said, well, if you're right, Mr. Shaw, about if the freehold was acquired on trust, should you at least give credit for the purchase price that was paid by GBRK, or alternatively the rent which had been paid? The answer I gave to, I think Mr. Holland was fairly dismissive of this, so I respectfully submit that was slightly unfair, but my answer was this, that no credit should be given to GBRK because GBRK's income had been generated using property belonging beneficially to GBR. We know that that business was diverted to GBRK. GBRK was only able to trade as a result of the 0.8 million contribution. So this isn't a case where the trustee has applied his own money. That's sort of Buller and Buller, where the court required the property to be retransferred on terms that the directors be reimbursed the purchase price. Here, you've got a case where GBRK's money has been generated using property belonging in equity to GBR. So why should GBR pay itself?
But we don't know that, do we? Because we don't know whether there was other trading income. We don't know whether the cash injections were used. That's just surmise.
Well, I mean, again, it depends. It comes back to my lady's point about the date. I mean, if you draw the line at the 31st December 2015, then it's not hard to say that on the 1st July 2016, GBRK was still trading with GBR's money. But I see that. I see the point your ladyship makes. I think one has to start with the appropriate cut-off and then work forward. That's all I was proposing to say on ground D. Unless the court has any further questions, may I move on?
Yes, thank you.
Ground E concerns the exercise by the judge of his discretion to refuse an account of profit against GBRK. This is dealt with in the judgment. Paragraph starts at 275, starts at paragraph 270 through to 275. The first point I make is that this isn't a true discretion at all. I mean, this isn't the award of an account of profit. This isn't like Part 44 award of costs. It's not like I understand my lady Lady Justice Macur practiced in the Founder Division. This is not sort of a section 24 Matrimonial Causes Act stuff. This isn't discretion in that sense. This just means it's the application of equitable principles. So, for example, late cheese is would be an equitable defence to a claim for an account of profit. I'll make that point good with just a reference to one authority. That's the decision of Mr. Justice Lewison in Ultraframe, which is authorities 1. Start with tab 29, page 637. Start at the foot of the paragraph 1579. The ordering of an account is an equitable remedy. It is not discretionary in the true sense. It is granted or withheld on the basis of equitable principles. One of those principles is that of proportionality.
Sorry, 1579, yes.
But one then comes into the authorities or in relation to when an appeal court can overturn a conclusion which is based on the judge's estimation of proportionality. And there are authorities about that also, and that is limited.
My lady, yes, the touchstone is proportionality, but what I say about this is that, I mean, insofar as I'm asking the court to revisit the question of proportionality, I say that Mr. Holland's decision is vitiated because it was based on mistakes of law, the mistakes of law being the construction argument, ground A, and also his conclusion that you need pre-existing trust property. If I could ask you now to turn back to the judges with the quantum judgment. If you go to page 355. And at paragraph 275, Mr. Holland gives 3 reasons for refusing an account of profit. The first one is the paragraph, well, it's the paragraph 272 issue. And also the question about whether GBRK received anything on the 23rd of June 2011 when the second lease was granted. I obviously say that that the judge was wrong as a matter of law. B is, I think, the legal consequence of the judge's findings on grounds A and what I call grounds A and B on this appeal. So the judge declined to hold the whole of the business of GBRK was held on trust for GBR as of the 18th of October 2011. I say that was wrong. And then I should say a few words about point C. The judge took into account the counterfactual world. So the fact that GBR would not have been able to trade before October 2011, well, that isn't relevant to an account of profit. I mean, that's Keach and Samford stuff. It's never been a defence to a claim for an account of profit that the principal would have been unable to make the profit. And then the judge goes on to make a point about double recovery. And I've dealt with this in my skeleton, but we say that this is just wrong. I mean, as a matter of basic principle, the way the courts deal with double recovery is at the execution stage. It's not at the judgment stage. I gave this example in my skeleton. It's in fact one that the judge himself relied on when he concluded that it was open to Mr. Davies to elect for equitable compensation against Mr. Monks and an account of profit against GBRK. Let's say you have a director who steals £100 from his company, Company A, and pays it to Company B. And within Company B then uses the £100 to make another £100. Well, assume that B received the £100 with requisite knowledge. Company A has a claim against Company B in knowing receipt for £200. It also has a claim against the director in equitable compensation for £200. Of course, I'm not suggesting that Company A should be able to collect £200 from the director and another £200 from the knowing recipient. That would be double recovery. But that wouldn't stop the court entering judgment or making an order for payment against the director and the knowing recipient. It's just one deals with these things at the stage of execution.
But if the issue is proportionality, why is this not a legitimate factor for the judge to take into account in deciding whether it's proportional toward this remedy in addition to the remedy against Mr. Davies?
Well,
I mean, Mr. Davies is good for the money, you know. There's no issue about that. He's paid what he's been ordered to pay. Or
Mr. Monks.
Monks.
Sorry, Monks. Beg your pardon. Sorry. Yes.
Well, I mean, I suppose to turn it round, I mean, in my submission there, well, we now know that Mr. Monks has paid most of what he was ordered to pay. The balance has been paid into
The court, yeah.
But I mean, of course, that wasn't the position when Mr. Holland gave judgment. I mean, I hope this doesn't come across as cheeky. I sort of turn it around the other way. So, why withhold a remedy against GBRK?
Yeah.
So I say that I am asking this court to revisit the question of proportionality. I say I'm justified in doing that because the judge's decision was based on errors of law. I think my interpretation of my learned friend's skeleton is I think it's common ground between us that proportionality is the touchstone for an account of profit. But what my learned friend says is that on the facts it would be disproportionate to grant any account at all against GBRK. And what my learned friends seek to do is to minimise the significance of the business diversion in the period between the 22nd of May and the 18th of October 2011. And again, to be clear, why the 22nd of May? What's important about that? That's the cut-off. That's the time bar for claims against GBRK. And so, what my learned friends want to say is, well, nothing of significance was obtained by GBRK in that 5-month period, and therefore no account of profit should be ordered. I'll address that directly, but before I do, I mean, of course, even if that were a good answer, that wouldn't help Mr. Monks. There's no limitation period against Mr. Monks at all. So, I mean, insofar as my learned friends are saying, everything significant happened before the 22nd of May. So GBRK got everything it needed to run a business before the 22nd of May. If that's right, and obviously I say it isn't, but if that's right, that may be an answer to a claim against GBRK. It certainly isn't an answer to a claim for equitable compensation against Mr. Monks. My learned friends rely on some analysis carried out by their expert, Mr. Hayward Crouch. He undertook some analysis to identify exactly what it was that GBRK got in that 5-month window between the 22nd of May and the 18th of October. And if I could just show you that, the easiest place to look is the supplemental report. Is his excuse me, Mr. Hayward Crouch's supplemental report. It's at file 3, tab 15. That's page 238. And what you see here is a summary of what Mr. Hayward Crouch had identified GBRK received. And so plant and machinery additions at just the heading above paragraph 3.4, plant additions 22,000 odd, capitalised expenses 3.5, reference to wheelie bins, skips and so forth. And over the page 3.9, you see 2 motor vehicles. And then improvements to leasehold improvements, capitalised expenditure, 312 office equipment additions, £8,000 of office equipment, and then 3.13, £75,000 of fixed asset additions. And then if you go to page 240, Mr. Hayward Crouch's conclusion at 3.18, in my opinion, I do not consider that the additions represent a material additional business or assets or business opportunities received in the period 22nd of May to 18th of October 2011. Our response to that is as follows, that this is I mean, number one, what Mr. Hayward Crouch hasn't taken into account here is the new customer contracts which were fulfilled by GBRK in that period. I haven't taken you to GBRK's accounts, but in its first year of trading, or just under a first year of trading, so its accounts drawn up to the 31st December 2011 showed realised profits of about 140,000. So GBRK was profitable from the get-go. I mean, of course, we don't know exactly within that 12-month period when the profits were made. Mr. Holland's finding was that GBRK started trading in February 2011, so 10 months from February to December. If you assume that GBRK was making profits, if you amortize the profits across the 10 months, that suggests that GBRK was making profits of, say, 14,000 a month. So significant profits were made in the 5 months. I also, and this is a point I put to Mr. Hayward Crouch in cross-examination, in fairness to him, he did accept it, that it's a very narrow approach to look at the assets which GBRK acquired in the 5-month period and say, well, what were they worth? And the computing equipment is the one that leaps out at you. But nobody buys computing equipment to leave it sitting on a desk as an ornament. The computing equipment was purchased in order to be employed within the business. And so it's artificial in my submission to focus solely on the cost of acquisition of these assets. When on this side of the court we have lots of criticisms to make of Mr. Monk's conduct, but he is an effective businessman. That's why he was hired in the first place. The court should proceed on the basis that the acquisitions of plant, machinery, skips, bins, whatever, in the 5 months were business decisions taken by Mr. Monks in the interests of GBRK, and they were sensible decisions which were then used to carry on trading. So what we say is that you can't. The 5 months of trading between the 22nd of May and the 18th of October were critical, and GBRK would not have been able to go on trading if it hadn't been. It would after the 18th of October 2011 if it hadn't been trading before then. Just to sort of to illustrate that with an example, let's just change the facts. I mean, let's say that GBRK had been incorporated many years before, and had an established business of its own. So let's say that GBRK had a trading business. It had drawn up accounts of the 31st December 2010, which showed that it was making profit. Needless to say, GBR would have no claim at all in respect of a business conducted lawfully by GBRK. And what you might say, on those changed facts, what you might say is, well, all that GBR is entitled to is an account of profits in respect of that additional bit of the business which was wrongly diverted to GBRK, but not in respect of GBRK's existing business. But GBRK didn't have an existing business here. As Mr. Holland found, GBR and GBRK started in the same place. The only difference between them was that Mr. Monks had a greater equity stake in GBRK. So, to wrap that up, we say that there is no proper basis for withholding an account of profit against GBRK. We know that GBRK received plant, machinery, etc. We know it was trading. It wouldn't have been able to trade beyond the 18th of October 2011 without the trading it was able to carry on in that period. And the appropriate place to draw the line is the 31st December 2015. I'll show you. I think it might have been Lady Justice Macur who asked me why I fixed on that date. But if I could just show you quickly the relevant parts of the liability judgment. If you pick it up at it's tab 16 of bundle 1, page 151, Paragraph 67, you see there's Mr. Johnson quoted an email from Mr. Davies. There's reference to growing the business and achieving exit in 3 to 5 years with a target of 5 million turnover.
Sorry, 67 was that?
So paragraph 67, page 151.
Yep. Sorry, thank you.
And then if you move forward to paragraph 81, this is Mr. Johnson was just dealing with made findings about the initial meeting between Mr. Monks and Mr. Davies. Mr. Davies' intention was to seek to build out the business operating at the site with a view to resurrecting at some future stage the plan to sell it, which had failed to come to fruition. And then paragraph 82, that interpretation is borne out by subsequent events. And at paragraph 85, Mr. Johnson describes the heads of terms, summarises them rather. And if you go to page 156, Roman numeral 5, the ultimate target was 5 million turnover for GBR. The financial year ended 31st December 2015. And then 87, sorry, just by way of, Mr. Monks said he didn't recall seeing that email with the heads of terms, but Mr. Johnson's finding was that the heads of terms reflected and summarised the outcome of discussions that had already taken place. And it's entirely logical to suppose a document of that type would have been sent and received by Mr. Monks around that time. And then you move forward to paragraph 100 of the judgment.
But do we need to look at 89? The final sentence. In Mr. Monk's favour, I agree that although the HOT is not a document having contractual force, it also evidences an understanding that subject to the proposed factoring agreement being put in place, the parties intended to have discussions about further capital investment in GBR.
Yes, well, I mean, I can't. What I can't say is that there was a concluded shareholders agreement which provided, for example, that after a period of trading for 5 years there would be an exit. But
well, can you say that there was any agreement reached?
Well,
apart from having further discussions.
I can. If you move forward to paragraph 100.
Thank you.
And then paragraph, if I could just ask you to read paragraphs 100 and 101, I mean, that's as far as I can take. It's the judge's finding at 101, that's as far as I can take it.
Yeah, and this was the agreement reached between Mr. Ford and Mr. Davies. Is that right?
Well, this was.
It was the handover note.
Yes, the handover note was sent by Mr. Davies to Mr. Ford.
And the judge, liability judge, accepted Mr. Monk's evidence on this point, that he never saw the handover note at the time. But goes on to say, that's not to say, however, that he must have been completely ignorant of the matters reflected. And it seems to me he must have been aware, at least at a general level, of the plans, some of which directly related to him.
So I can't say that there was a concluded agreement, but I do say that there was a general awareness of the plan, and that was a 3 to 5 year time frame. And what I say now is that the right date is the 31st December 2015, because that gives effect to the parties' understandings as found by the liability judge. and if one takes a step back, as I say, proportionality is the touchstone. That does give Mr. Monks and his co-shareholders 7 years of upside. So everything beyond 2015, beyond the 31st December 2015, he gets to keep.
And what about the paragraphs that follow?
Well, the formalities for the implementation of the structure weren't implemented. The arrangements weren't formalised. That was the judge's finding. My learned friends rely on. If you go to page 188, in answer to my point about the parties' commercial intentions, my learned friends rely on paragraphs 249 to 251, and they say, well, there was no agreement. My short answer to that is that this is what Mr. Johnson was addressing here was whether whether Mr. Monks had entered into a contract of employment. So this just isn't on point.
Okay.
Unless the court has any further questions for me on the account of profit, I propose to move to the question of equitable compensation. You'll be pleased to hear I've actually covered a lot of the ground here already because I took you to FHR.
Yeah.
The judge concluded that the claim for equitable compensation was compensatory in nature. So it's the function of an award of equitable compensation was to compensate GBR for loss. And that's why the counterfactual was relevant. The judge found that GBR would not have traded beyond October 2011. And it's for that reason that that was the date selected by the judge. So GBR was not entitled to equitable compensation in respect of the value of GBRK beyond October 2011. And I submit that that's simply the wrong approach to equitable compensation in this type of case. I won't take you back to it in the interest of time, but I refer you when you consider this appeal. I ask you to look again at paragraphs 1, particularly paragraphs 1, 6, and 7 of the judgment of Lord Newburger in FHR, where Lord Newburger said in terms. Equitable compensation, it's restorative. It is, in essence, it is equal to the profit made by the fiduciary. There's nothing to do with loss. The dishonest director who receives a bribe is obliged to pay equitable compensation equal to the amount of the bribe. So it's not about compensation at all.
Surely there are lots of cases that say that's precisely what it's about.
But not.
I mean, the bribe cases, aren't they? They're the outliers. I mean, there are cases where you have a special rule dealing with bribes, where all sorts of public policy considerations are engaged as well. But surely, I thought this was the point that was made absolutely clear in Target and Red Ferns, or no, one of those cases. That the nature of equitable compensation is indeed very much parallel to an ordinary award of damages. You have to establish loss and some kind of causative link or something of that nature. Therefore, a counterfactual is inevitably part of the exercise.
Well, I was going to take you to AIB and Redler, because of course that discusses target holdings.
Yes, absolutely.
But I mean, my learned friend obviously relies on that. That's
Well, absolutely,
the sheet
yes.
anchor of his
Well, it is Supreme Court authority.
Well, it is, but I mean, but my submission is it's not. The Supreme Court wasn't dealing with equitable compensation for this type of breach, and that's not a clever interpretation of mine. Lord Reed said in terms, I'll show you the passage, but in AIB and Redler, Lord Reed said, he referred to FHR, and he said, equitable compensation means something different. He made it perfectly clear. He was that the principles discussed in AIB and Redler for equitable compensation, they weren't the same principles that applied to equitable compensation, the purpose of which is to deprive a fiduciary of his secret profit. But so, your lordship raised it. Let's go to AIB and Redler.
Yeah, thank you.
It's authorities to tab 46.
I think that's authorities 3 then, isn't it?
Yes, yes.
Sorry, pardon. I'm sure the court is familiar with the facts of this case and also Target Holdings. These were essentially solicitors' negligence cases. These weren't. It is an important point, and it's reflected in the way that the principles are expressed. They were commercial. The background to the claims were conveyances. In Target Holdings and AIB, banks advanced money to solicitors to be held, to be paid over to the borrower on completion. In Target Holdings, the solicitors paid the money over too soon, but the bank obtained the charge which it always bargained to receive. In AIB and Redler, the facts were similar, but not quite the same, because the solicitors were only entitled to release the trust money on confirmation that a prior charge had been released. And as a result of an honest mistake, they missed the fact that there was an outstanding balance due to the chargee, and so they paid the money over. The first chargee and the claimant bank then did a deal under which the first chargee agreed to subordinate its charge, save in respect of the outstanding balance of about 200,000. So, just taking a step back, in AIB and Redler, the bank got almost all it bargained for. Not quite, but almost all it bargained for. And in each case, the Supreme Court rejected an attempt by the claimants to visit market losses on the solicitors. So the loans were bad. The properties there were defaults. The properties were realised, but the security wasn't nearly valuable enough to cover the outstanding borrowing, and so the claimants were no doubt fishing around for claims. And what they said, and in each case, what they said is that the solicitors were in breach of trust for handing over the trust money, and that was the end of it. And so the solicitor's liability was to restore the trust property, and that's really the first point to make about these cases. The context is very important. These were, as the Supreme Court emphasised in AIB, these were trusts which were the boundaries of which, if you like, were established by the terms of a contract. I mean, the bank entered into a contract with its conveyancing solicitors. The idea was that it was always the case that if the trust was performed, the trust would be exhausted, and the bank would become a creditor. The relationship would change, so the bank would no longer be a beneficial owner of money. The bank would become a lender. So it's far, far removed from this sort of case, which is a sort of dishonest diversion of business case. But if I could, I mentioned what I say is the key passage in Lord Reed's judgment. That's at. I'll go back, but I'll just show you that because I mentioned it. If you go to it's tab 46, paragraph 120 of the judgment, pages 1800 to 1801. And Lord Reed noted that a personal claim to payment of an amount brought.
I'm sorry, I'm lost, Mr. Shaw. Paragraph?
I do beg your pardon. It's paragraph 120.
Thank you.
In the AIB judgment.
Yes, yes.
So, what I take from that is that the Supreme Court didn't intend to address the sort of secret profit type case. Lord Reed is noting that, I mean, it's needless to say, Lord Reed is not suggesting that FHR is inconsistent. Nobody suggested that the judgment in FHR is inconsistent with AIB. It was just regarded as addressing something different. There is an interesting forensic point to be made here about the dates upon which the AIB appeal and the FHR appeal were heard. You see that the AIB appeal was heard on the 5th of June 2014. If you go to the FHR judgment, tab 47B, that was heard by the Supreme Court just a couple of weeks later, in June 2014. And you see that Lord Neuberger sat on both appeals, and he gave the lead judgment in FHR. Clearly, this court should proceed on the basis that Lord Neuberger hadn't forgotten what was said in AIB when he gave judgment in FHR, or vice versa.
So when was the judgment in FHR? Because AIB was November the 5th.
16th of July.
So yes, I've tried to. The 16th of July is the best I can do, my lady.
So 16th of July for
FHR.
FHR.
Yes, one sees that at page 1847.
And then 5th of November for AIB.
Yes. And there's no suggestion that there's inconsistency as between these cases. And so, of course, I can't ask this court to depart from AIB or target holdings, but I just say that it just isn't. Those cases are just not relevant to equitable compensation in this type of case.
Well, I'm not sure about that. I mean, after all, the judgment of Lord Toulson, which you haven't taken us to, and that was the leading judgment in AIB, I think. I mean, that was absolutely really directed to dealing with criticisms which had been made of Lord Brown-Wilkinson's judgment in Fargate. And basically, he ended up giving it a clean bill of health, I mean, subject to some footnotes. And the whole thrust of that line of authority was that equitable compensation in the normal type of case, at any rate, is of a I always find these labels rather not particularly helpful, but intended to make good a loss. I mean, reparative in the jargon, rather than restitutive.
Yes, but I don't accept that FHR is a sort of out on a limb. You do find references in the cases to, of course, nobody wants to encourage bribes. I see the policy point,
yeah.
But the decision in FHR is not it's not confined to bribes, and we don't need to go back to it. But when Lord Neuberger looked at the question of remedies, he applied general trust law. He didn't just look at bribe cases. He addressed my favourite Buller and Buller, for example. So, I mean, my primary submission is that for this type of case, equitable compensation is restorative, and AIB and Redler and target holdings just don't come into it. But if I'm wrong about that, then I rely in particular on the passages in the judgment of, well, Lord Toulson and Lord Reed, when they emphasise that they emphasise the commerciality of the thing. And so you pick that up, say, at paragraphs 33, 67, and 70 through to 75. It's not difficult to see why the Supreme Court didn't want to fix the solicitors with liability, with the market loss. That's not difficult to understand.
Yeah.
Again, these epithets are perhaps not very helpful, but the bank got what it bargained for, entirely in target holdings, almost entirely in AIB. That sort of analysis just doesn't work in this sort of diversion of business case. The third point, and so beginning by way of fallback, is just to say it's a point about the extent to which the court can hypothesise. In target holdings, the court didn't need to hypothesise at all. All the court did was look at what actually had happened. The bank got the charge. In AIB and Redler, all the court was doing was applying hindsight. The bank got a first-ranking charge, save in respect of the 200,000 odd, which had been repaid to the first chargee. That is a very different exercise to the one which Mr. Monks invited Mr. Holland to engage in, which is to say, if I hadn't been dishonest and I'd done what I should have done, the following would have happened. So there is a material difference here. Target holdings, if target holdings and AIB Redler establish that equitable compensation is always compensatory, save for bribe cases, and the court will understand I don't accept that. But if that's right, then they certainly don't stand for the proposition that in a case of business diversion, what the court should do is sort of go back to the beginning and say, well, if the director had performed his duty of loyalty, this is where we would have ended up. What I'm really saying is that in AIB and Redler and target holdings, the court didn't need to engage in speculation about what might have happened. It was clear what happened. You knew the bank got its charge, and the loan was made. So, I mean, again, for those, I'm distinguishing those cases on the facts. So, for those reasons, I say that AIB and Redler and target holdings just don't operate. They don't support the proposition that in a case like this, equitable compensation is compensatory. This is all about putting back trust property. This is all about restoring trust property. And Mr. Monk's obligation as a fiduciary was to put back the trust property where it should have been, and that was giving it back to GBR And the question of whether GBR could have operated the business itself is neither here nor there. We then get to the question of valuation. I mentioned the 19th century case Nancy Glow. How much compensation is to be paid? The director has got to restore the trust property in specie if he can. If he can't restore it in specie, then he's got to pay equivalent value. So what is the value? It is clear that one applies hindsight. The court is not blinkered by value at the point of diversion. If I could ask you to take up, it must be bundle 1.
Sorry, did you say authorities?
So authorities bundle 1, yes.
Yeah.
There's tab 2. I've already explained to the court what happened in this case, but the director received a secret inducement of 50 shares. Those shares went up in value to £80 a share. But by the time of the trial, the price had fallen back to £1 a share. The director appears to have been willing to hand over the shares, but the court held that that wasn't good enough. If you turn to page 9, the last paragraph beginning in July 1877. See that what the claim was for. If you then go to page 17, it's the part of the judgment that I've highlighted.
Excuse me.
The Vice-Chancellor noted that the value of the shares was £80 each in September 1871. The shares are now worth £1. Now, at the foot of the page, I can find no authority which has been referred to for saying that the justice of such cases would be met now that the shares which were once worth £80 are only worth 20 shillings by a mere restoration of those shares. And then if you look at page 19, the minute of the judgment, you can see the relief which was granted. The director was ordered to pay the sum equivalent to £80 a share.
So at the beginning of your submissions, you told us that this was referred to in which case?
It's referred to in FHR. I mean, as my Lord Sir Launcelot correctly noted, it's ported by way of introduction, if you like, but it certainly is. It's referred to by the Supreme Court. So what I take from that is that in ordering a fiduciary to pay compensation, the court is not restricted to the value of the date the date the secret commission, in that case the shares are received. The court is entitled to apply hindsight, and the beneficiary is entitled to the highest value between diversion and trial. On the facts of that case, was that a harsh outcome for the director? Yes, it was, and it was intended to be, because this is all about deterrent. Before we move to the final ground of appeal, which is one I can deal with very shortly, I would like to just make some comments about the Libertarian Investments decision, the decision of the Hong Kong Court of Final Appeal. That is because Mr. Holland relied on the short judgment of Lord Millett, who was sitting as a permanent justice of the Hong Kong Court of Final Appeal, in concluding that equitable compensation was all about compensation for loss. Libertarian Investments is bundle 3, Authorities Bundle 3, tab 43. It's very important that I explain the facts of this case, in order for the court to understand what Lord Millett's comments. This was this might be classified as a sort of breach of custody type case. The claimant gave the defendant, Paul, a very large amount of money for the purposes of buying shares in Betfair shares. The fiduciary Hall acted in breach of trust. He misappropriated some of the money and didn't buy any shares at all in Betfair, although claimed he had done so. After he should have bought shares in Betfair but didn't, a public offer was made for Betfair shares, and the holders of Betfair shares were able to sell at a premium. So this was a case in which the trust never got the property it should have got. I'll just show you where. Yes, if you go to page 1612, it's paragraph 30. I could just ask you to read the crucial findings. So this was a claim for equitable compensation, but it was essentially a claim to put the trust in the position it would have been in if the trustee had performed. So with that background, I would ask you please to move forward to the short judgment of Lord Millett, which starts at 1656. Lord Millet begins by describing the process of taking an account, and by that he didn't mean an account of profit. He meant the exercise of being before a chancery master and the trustee having to justify what he's done with trust property. That's a 168. An order for an account does not provide a remedy. It's the first step in a process. The judge then referred to the process of falsifying or surcharging an account. This is liable to confuse, but my submission is that in this sort of case, which is about business diversion, really falsifying and surcharging an account, those principles are not applicable. Just to explain what I mean. In a custody type case, let's imagine that I hand a trustee a sum of money and I tell that trustee, I want you to buy shares in Shell for me. And the trustee acts in breach of trust and doesn't buy shares in Shell but buys shares in BP instead. Now, I have a choice. I have an election. I can either say, I don't recognise that your purchase of BP shares. I am going to treat you as having spent your own money buying the BP shares, and therefore I'm going to falsify that I'm going to falsify your extraction of funds from the trust, and require you to repay the amount you spent on the BP shares. The alternative is I can say I ratify that transaction. Although I didn't give you authority to buy BP shares in the first place, I will ratify it, and I will treat those shares as trust property. Now, in that case, there's an election, but that doesn't really make any sense when you're dealing with diversion, because the assets which are diverted are trust property from the beginning. Of course, it'd be a slightly odd thing for a company to do, but a company could decide to waive its interest in trust property, assuming the company is solvent and the members agree. If a director has diverted business to himself, the company could say, fine, keep it, subject to questions of solvency and so on. But it doesn't really make any sense to talk about falsifying the property. I mean, the diverted business belongs in equity to the company. That's automatic from the moment of receipt. And so this process of falsifying and surcharging the account is, in my submission, not applicable. But it's apt to confuse. But it just isn't applicable in this sort of case. And then, if you can just read, if the important paragraph here is paragraph 170, and it's the final sentence that Mr. Holland relied on. And what Mr. Holland said is that this sort of case, this diversion case, is about the fiduciary not acquiring property which he should have acquired. But that's just wrong. This wasn't a diversion of business case. This was a fiduciary who should have bought Betfair shares and didn't. And so that's what Lord Millet, that's what that comment was directed at. The principle in the claimant libertarian investments was saying, I want you, Mr. Hall, to put me back in the position I would have been in had you gone out and bought the Betfair shares that you should have bought for me. So it's got nothing to do with diversion of business. So for that, I say that Mr. Holland's reliance on that sentence was misplaced. Lord Millet just wasn't dealing with a director who takes for himself business which should be taken by the company. Unless the court has any further questions on that, I was going to move on to the final ground.
Thank you.
This really is a very narrow point. if I could ask you to take up the quantum judgment. It turns on paragraphs 183 and 184.
Oh, is this the point about the equitable allowance?
Sorry, it's 182 and 183, yes.
And whether it's
the
the £3,000 per month is additional or not?
It is, and I mean, you've seen what I've said about it in the skeleton. The judge has awarded Mr. Monks an equitable allowance of £3,000 a month. We looked earlier at the handover note. That's where we accepted that Mr. Monks was entitled to £3,000 of remuneration a month, and so I don't take a point about an equitable allowance in that amount. But what I do object to is that what Mr. Holland has not done is taken into account the remuneration which Mr. Monks in fact received. And
well, that rather begs the question, because the judge did expressly say it was additional to anything else he may have received.
Well, he did, but there's a story to be told about this, because at paragraph 182, the judge said it would be wrong to allow Mr. Monks anything more than £3,000 per month, which I find was contemplated by the agreement described in the handover note. So just pausing there, what the judge's finding is that Mr. Monks should not be allowed more than was expressed to be the remuneration in the handover note. And I say, as night follows day, in order to apply that, you would need to take into account what Mr. Monks actually had. But then paragraph 183 is inconsistent, because what it says is that for the avoidance of doubt, the sum is in addition. Now, that final sentence was added. What happened here was that when we received the draft judgment, I mean, also there's a very we understood entirely that we could put forward editorial corrections and immaterial changes, but it seemed to us this was such an obvious point. This was something which could be dealt with by way of clarification. So we pointed out to Mr. Holland that what he hadn't done was taken into account the remuneration which Mr. Monks had in fact received. And it was that which led to whether the addition of for the avoidance of doubt sentence. But we do say that there is an obvious inconsistency here. We support the analysis at 182. If Mr. Monks should get what again, this goes to the commercial intentions of the parties. It was intended that Mr. Monks would have £3,000 a month, so we have no issue with that. But he shouldn't have had more than that. And so we do invite the court to disallow, or put it a different way, we do ask this court to vary Mr. Holland's order insofar as it refers to equitable compensation, equitable allowance, by requiring the remuneration he in fact received to be added back before 30,000 is deducted.
I'm a little bemused by this, but because the judge writes 182, you ask for clarification, he inserts 183, which is plain as a pikestaff, and now you say, but 183 is inconsistent with 182. But you asked him the very question, and he inserted 183. And when you look at that and read it with 182, which is about the allowance, I just don't see where you've got any wriggle room, Mr. Shaw.
Well, I'll have a go.
I just.
I mean, I don't want to repeat myself, but I do say that there is inconsistency in the approach, because at 182, what the judge, our reading of it is that he's saying, well, that Mr. Monks could have 3,000 a month because that's what the handover note said, and that accords with the party's commercial intentions. Well, and it would be wrong to give him any more. But if 30,000 is in addition, then Mr. Monks has had more.
I understand.
Paragraph 180, and this is, one of the things referred to above. Mr. Hall, in evidence that was not challenged, asserted that GBRK's financial record showed that Mr. Monks in fact received payments from GBRK in the period to December 2011 of 78,000. While this, of course, does not necessarily directly affect the question of whether and to what extent Mr. Monks is entitled to an allowance in respect of equitable compensation, which is ordered to pay to GBR, it does at least show that he was in fact remunerated for his efforts in the real world. Further, the receipt by him of such sums would, in my view, have to be taken into account in the valuation of GBRK as at October 2011, as it would have been a factor contributing to the financial state of GBRK as at that date. So to an extent, an award of equitable compensation based on the value of GBRK has already taken into account certain payments made by that company to Mr. Monks.
Yes, what the judge is saying is that GBRK's value was reduced to some extent by the fact that Mr. Monks had been paid.
But the value of GBRK was taken to be the multiple, the correct multiple of the £20,000 investment of Mr. Simmons, and that was on the basis that Mr. Monks was the driving force.
Well, my lady, this is really a valuation point, I think, rather than a legal one. But I mean, if this, I see your ladyship's point. If this, the company was valued by reference to an equity investment, which was taken as a proxy for the value of the whole company. If you were valuing a company on a net assets basis, then clearly you would take it. Then the amount paid out by way of remuneration would be directly relevant.
Yes.
But I think what I interpret Mr. Holland's comments here to be, he considered that the 0.8 million, so the value of GBRK, reflected the remuneration which Mr. Monks had received. So if you like, if Mr. Monks hadn't been paid remuneration, GBRK would have been worth more. That is, I understand, what Mr. Holland was saying. So it really goes to this point about double counting. Mr. Holland's view here is that the value of GBRK was reduced because Mr. Monks had received remuneration. So that meant Mr. Monks paid less by way of equitable compensation to my client than he otherwise would have had to. So he gets an allowance in that sense already.
Well, I think what I'm trying to say in a very clumsy way is that the judge appears to be aware of that. It isn't as though he's overlooked it. And if we read the whole of that part of the judgment from 176 to 183, yeah, we have to look at that again, don't we? All right, together.
Well, I'm not sure there's much I can add, but it would be pretty remarkable if the judge had taken the view that the payment of remuneration had increased the value of GBRK. I mean, he certainly can't have been saying that.
No.
So he must have had in mind that the remuneration received by Mr. Monks had reduced the value of GBRK, and that obviously fed. I mean, that was to Mr. Monks' advantage when it came to the quantum judgment, because it reduced the amount that Mr. Monks had to pay to my client.
Yeah, 177. Mr. Holland refers to the joint expert, Mr. Granger, who gave unchallenged evidence that the market rate for the remuneration and other benefits of a director of Greenbox Recycling Kent for the period Jan 2011 until June 2020 was 89,815, comprising a salary of 81 and bonus. Yeah, okay.
178. I said, Mr. Holland said, I cannot accept Mr. Monks was unaware that he was at least initially only to receive 3,000 a month, which I say rather supports my case.
Yeah. Yeah.
And I can see the force of the point that it does seem a little odd to fix on an amount of £3,000 per month. Apparently, on a literal reading of what is said in 183 is going to remain unchanged regardless of how much
He in fact received.
he has in fact received from GBRK in the relevant period. And it just seems a peculiar approach.
Well, I respectfully sort of endorse that, and you might say, well, what was the relevance of the handover note in that case?
Yeah. Whereas your construction does, on the face of it, make more commercial sense, which is you tot up the £3,000 per month, and then set it off against whatever has been in fact received.
Yes, that's the submission.
Yeah.
Unless the court has any further questions for me, those are my submissions, and I'll draw stumps.
Thank you very much
Thank
indeed.
you.
Very well done. So, Mr. Cook, we won't start now, but would you just give me a moment? Mr. Cook, Mr. Shaw, would it be convenient to start at 10 a.m. tomorrow?
Is this with the intention of getting through the appeal and some of the cross appeal tomorrow?
Yes.
It's certainly convenient from our perspective to start at 10.
Yes, I'll commit to that. I mean, how I'll get to work, I'm not sure, but no,
Oh, I
we'll
see.
let's stick to 10.
No. I mean, if it's going to be difficult.
No. I mean, no. I'm sure where there's a will, there's a way. It'll be fine.
Right. No, I don't want to put you under pressure. So you know that you could be here for 10:30.
It was just simply. I think it's the rail strike tomorrow as well, isn't it?
It is. But you got here for 10:30 today. That's the only reason I'm saying.
I'm sure it'll be. No, really. 10 o'clock is absolutely fine.
Well, obviously, if you're not here, we quite understand.
We won't start without you.
No, we won't. All right. So, okay. And Miss Cook, you were saying, is that with a view to? Was there something you wanted to add to it?
Well, only that I'm very doubtful I'd be able to get through all of my submissions in response to Mr. Shaw's and cross appeal tomorrow.
Yes, we're just trying to get ahead of
Yes.
where we're going to be at the start of day 3.
Yes.
All right. Thank you. Mr. Shaw, could your solicitor please provide me with a new bundle for file 3 of the authorities, because it's not very easy to get through to the relevant citations.